This video lesson will guide you through a comparative analysis of the UK and US constitutions. I'm going to be referencing pages 47 to 54 from Chapter 2 of US Government and Politics, which you have access to as a PDF. We will divide our comparative analysis into the origins and development of the constitutions, the key principles, the nature, and the role of the judiciary and constitution in safeguarding individual rights. So we will have 4 themes of comparison. There is a corresponding worksheet shown here that you can use to take notes from this video, and of course you can use the chapter I just mentioned to supplement your notes. All of this action will help you to prepare for the 20-mark essay on this topic, which we will tackle after this lesson. Let us first take a look at the origins and development of both constitutions. What is different about the two constitutions is the manner and context in which they emerged. The US Constitution was born out of a revolution and almost fully formed in 1789. In contrast, however, the UK Constitution has evolved over time. The US Constitution developed and was shaped by political upheaval and sought to ensure that specific values and ideals would always be upheld. These ideas included liberty, individualism, equality, representative democracy, limited government, states' rights, and the rule of law. The US Constitution emerged during a period of revolutionary change and from a desire to free the US and its people from autocratic British monarchy. As society and time progressed, the US Constitution developed to include the Bill of Rights and amendments securing the end of slavery, for example. In contrast, the UK Constitution developed within a different context. While some historic documents, such as the Magna Carta of 1215, did respond to excessive royal power, fewer constitutional amendments in the UK came about in response to a desire for radical change. That said, constitutional reform has occurred in order to reflect society and its developments. The inclusion of the Human Rights Act of 1998 into UK law is a case in point. Let's now turn our attention to the key principles of the two constitutions. The UK Constitution is founded upon the key principle of parliamentary sovereignty, which means that the Westminster Parliament is the supreme lawmaking body. The rule of law is also a key principle, as it is in the US, and this means that no one is above the law. Another key principle of the UK Constitution is that it establishes a parliamentary government under a constitutional monarchy. This means that the UK has a political system in which the monarch is the formal head of state, but the monarch's legal powers are exercised by government ministers. In the US, the president is the head of state. The UK Constitution also lays out where political power lies. The UK is a unitary state. This means that political power is concentrated in the centre. Legal sovereignty is retained by the Westminster Parliament. However, given that a degree of political power has been devolved to the nations of Scotland, Wales, and Northern Ireland, the UK feels less of a unitary state. This does not mean that the UK is becoming more like the US and becoming a federal country. Although some political power is given to the devolved nations, Westminster, or the national government, remains sovereign. All devolved governmental power exists only with the agreement of the national government. The difference in the key principles of the two constitutions is perhaps strongest when we consider the different systems of government, federalism versus devolution or the unitary state. Checks and balances on the powers of the branches of the US institutions, the executive, judiciary, and legislature, is a key principle of the US Constitution. For example, the president can check Congress by vetoing a bill it has passed. Congress can check the president by using the impeachment and trial powers to remove the president from office, and can check the powers of the federal courts by proposing constitutional amendments to overturn a judicial decision. The federal courts can check Congress by declaring a law or the president's actions unconstitutional. The UK Constitution does not stipulate such separation of power. In fact, it is said that under the UK Constitution there is a fusion of powers. The Prime Minister draws up proposals for new laws which are almost guaranteed to pass if the Prime Minister's party has a majority in the House of Commons. Power is concentrated with the executive in the UK. This means the Prime Minister and their cabinet, and while there are opportunities for scrutiny, it is quite different to the US context. Let us now turn to look at the nature of the two constitutions. The two constitutions differ in nature. The UK constitution is not entrenched and can be amended by a simple act of Parliament passed by Parliament. The UK constitution is uncodified, so there is no single authoritative document. Instead, the rules and principles governing the state are found in a number of sources, both written and unwritten. The US has a codified constitution, which means that the rules and principles governing the US are collected in a single authoritative document. The constitution is entrenched and difficult to amend. The courts can determine whether the actions of others, including the executive and lawmaking bodies, are unconstitutional. Our fourth and final theme of comparison is the role of the judiciary and constitution in safeguarding individual rights according to the UK and US constitutions. In the UK, the Human Rights Act of 1998 is incorporated into UK statute law. This means that individuals are, in theory, protected by these rights in a court of law. The UK does have a Supreme Court, however, it does not have the power to strike down acts as unconstitutional as is seen in the USA. This is because statute law remains the supreme source of constitutional law in the UK. That said, the UK Supreme Court is able to clarify the legal meaning of a particular law or regulation. This is known as judicial review. Judicial review in the UK is generally regarded as less significant than in the US. Although in January 2017 the UK Supreme Court did rule that since the UK government had triggered Article 50 of the Lisbon Treaty in order to get formal negotiations with the EU underway, this would overturn existing UK law, so MPs should be allowed to vote on what would be a significant constitutional change. The case of Tajere versus Secretary of State for Business, Innovation and Skills in 2015 highlights the way in which the Supreme Court was able to use the Human Rights Act as part of the UK Constitution to protect the rights of the individual. Ms. Tajere, who had arrived in the UK from Zambia aged 6 and subsequently completed her A-levels, was not eligible for a student loan for her undergraduate degree because she did not have indefinite leave to remain in the UK and would not be able to apply to the UK Border Agency for this until 2018. In 2015, the UK Supreme Court accepted her appeal on the grounds that the negative impact on her rights under Article 2 of the Human Rights Act, the right to education, and also Article 14, prohibiting discrimination, could not be justified, as this clip will show.
Judgment in the appeal of the Queen on the application of Tajere and the Secretary of State for Business, Innovation and Skills.
The appellant came to this country from her native Zambia at the age of 6. She and her mother came because her father had a student visa to study in this country. 2 years later, her father went back to Zambia, but her mother stayed here, and so did she. Unbeknownst to her, they had no right to do so. She went through the whole of the English school system, reception, primary, secondary, and sixth form college. She worked hard and did well. She was head girl of her secondary school, and she gained 7 GCSEs and the equivalent of 3 A-level grades of A star, A and C. She was offered places at several universities and accepted a place to read international business management at Northumbria University. To do this, she needed a student loan. She applied online and discovered that they needed information about her immigration status. Having taken legal advice, she discovered that she did not qualify for a student loan on 2 counts. First, because she had not been lawfully, ordinarily resident here for 3 years. The authorities had caught up with her and her mother 7 years after they should have left, but had given them temporary admission to the United Kingdom. 2 years after that, and 1 year before her application for a loan, they had been given discretionary leave to remain. But temporary admission does not amount to lawful residence, and so she could not fulfill this criterion then, although she can do so now. And secondly, because she was not settled here in the sense of having been granted indefinite leave to remain. This is only granted where a person has had discretionary or limited leave to remain here for a probationary period, which in her case is 6 years, but in later cases will be 10 years. She challenged the requirements of, firstly, 3 years lawful residence, and secondly, settled status, as either Firstly, an unjustified interference in her right to education under Article 2 of the First Protocol to the European Convention on Human Rights, or secondly, unjustified discrimination on the ground of her immigration status in her enjoyment of that right, contrary to Article 14 of the Convention. Obviously, she is not the only would-be student in this or a similar situation, and so this case is important for them as well as for her. The court unanimously holds that the requirement of 3 years lawful residence is justified. But by a majority of 3 to 2, it holds that the requirement of indefinite leave to remain is not justified. The aim of the requirement is to target student loans on those who are not only likely to stay on here afterwards and contribute to the economy through their enhanced skills and the taxes they pay, but from whom it will also be easier to collect repayments of the loans through the tax system. The evidence is quite clear that university education benefits not only the individual, but also the economy in a variety of ways. But this particular rule is not rationally connected to that aim, because it excludes students like the appellant who have spent their whole educational lives here, who cannot in reality be obliged to leave the country, nor would they wish to do so, and who will therefore remain here to contribute to the economy and repay their loans. The court therefore allows the appeal and declares that the denial of a student loan to this appellant on this ground would infringe her convention rights. The minority consider that adopting this rule was within the discretionary area of judgment which the court should allow the government in a case of this sort.
The US Constitution does not incorporate the Human Rights Act. It has its own Bill of Rights, and the Act of Judicial Review offers greater scope for individuals to challenge legal decisions or actions. In June 2020, the Supreme Court in the USA ruled that the language of the Civil Rights Act of 1964, which prohibits sex discrimination, applies to discrimination based on sexual orientation and gender identity. This was regarded as a huge victory for the LGBT movement in terms of the protection of individual rights and equality, as this clip will show.
This is an NBC News special report. Here's Kate Snow.
Good morning. We have breaking news from the Supreme Court. It is a landmark decision for the LGBTQ community. The justice is ruling that it is illegal for workers to be dismissed from a job based on sexual orientation and gender identity. NBC Justice correspondent Pete Williams joins us with all the details. Pete, what can you tell us?
Well, this is a stunner, frankly, coming from this conservative Supreme Court that no longer has Anthony Kennedy among the justices, the man who wrote all the gay rights decision before. But today the Supreme Court has ruled that Title VII of the Civil Rights Act of 1964, which makes it illegal for employers to fire employees on the basis of sex, also covers sexual orientation. Now, the lower courts had been divided on this, and the Trump administration sided against this ruling, saying no, that when Congress passed the Civil Rights Act in 1964, nobody was thinking about sexual orientation. It was simply discrimination against men or women. But today the Supreme Court said, no, that's not the case. Sexual orientation is considered part of that 1964 Civil Rights Act. Now, this is a victory for an Atlanta man, Gerald Bostock, who worked for the county and was fired after his employer discovered that he was on a gay softball team. He sued, and the lower court said, sorry, you can't sue under the Civil Rights Act. It doesn't cover sexual orientation. And today the Supreme Court said that's wrong. It's an issue that had divided the lower courts. Now, on the same day that this case was argued, the Supreme Court heard a separate case on whether it's also illegal under this same civil rights law to fire someone for transgender status. We don't have that decision. The Supreme Court, as you know, in this time of the pandemic is not actually in the courtroom. All this is happening virtually. And frankly, all we have so far in the decision is the very first page. But I'm told now that it's starting to line up. And the vote is 6-3 with Neil Gorsuch, one of the Trump appointees, joining the Chief Justice John Roberts and the court's 4 more liberal members to form this 6-3 majority. So this is a huge thing, and I would just say one other thing about this, Kate. Gay rights groups considered this even more important than the fight for marriage equality, because while not every gay person in America gets married, most gay adults want or need a job. And as of just a few minutes ago, it was possible to get married on Sunday and legally fired on Monday, but no more. Kate?
And Pete, you mentioned Neil Gorsuch. You had told us when we were preparing for this possibility today that he argued in the arguments, indicating that he might accept this argument that these rights are covered by that statute.
Yeah, he said that actually more in the transgender argument, but he seemed to be among the conservatives the one that was distantly possible to maybe be peeled away to join the majority, and that's what he's done here. We'll have to see what the logic is as this this thing is. I guess there are so many people on the Supreme Court website that the pages are loading very slowly, but at least we know what the bottom line is, Kate.
Well, why don't we let you read that, Pete, and I'll jump over to NBC's Peter Alexander at the White House, who's with us as well. Peter, this is a landmark ruling. Any reaction yet from the White House?
No, Kate. Actually, we just reached out to the White House moments ago. We haven't heard from them yet. The president's been tweeting on other topics over the course of this day. This has not been top of mind from him. But, LGBTQ activists and allies have said there really has been this whiplash between the Obama administration and the Trump administration in terms of their policies on issues related to the gay community. So this will certainly be hailed as a victory in those communities. What the White House's position on this will be interesting. We wait to hear from the president on this topic as we hear from him a little bit later. We know there has been a lot of focus on some of the other issues that the court's been reviewing as well, including issues as they relate to the president's taxes and the issue of DACA. On this one, though, certainly we're still waiting to hear from the president how he tries to frame this, even though his administration has been pushing to try to roll back a lot of the Obama administration's efforts to provide new opportunities and rights to members of the gay community. Kate?
So in conclusion, we can see that there are significant differences between the two constitutions. However, there are a few similarities when one considers the principle of the rule of law and the move away from complete central or unitary state power in the UK and towards devolution.